Thank you very much for the floor, Peter. And now I'm the one between you and the coffee break. So I will try to be as short as possible. And as you might have seen from the program, I was supposed to speak as the very last speaker today, but there was some change in our program. That's why I'm just here. It was the simplest solution. And if you already might have realized on the title of the section, this is the section in medias res, as we are, as said. So we didn't really have something very general, but we just started at the going to the heart of the problem, what we have. And now I would like to open this scope just a little bit. Then for the next session, just coming back to the more focused topics. So that's why I speak about a couple of things in order just to show the complexity of the issues, what we have from the angle of civil law, because that's my background. I'm a civil lawyer. So that's why everything I say is a perspective of a civil lawyer. And I would like just to show how much need for the transformation of our thinking is. That's a task for us lawyers. We have just to rewire our minds in a little bit. I think we should revisit the consumer protection framework. Later on today, we will have more presentations on consumer protection issues. And I also would like to address blockchain technology, but just in a very brief way, because we will have presentations from very high-level experts of blockchain today. And I would just go back to the ground at the very last part of my presentation, because I would like to address the problem of the applicable law to digital assets, because I think it's just a very real problem, what we have today. We might have heard, we actually heard from the introductory speech of our dean that disruptive technology, that's a word that we use very often, disruptive, and that's a very bad connotation because it disturbs us, that something happens which you don't really like. We lawyers don't really like the changes, but that's another issue. We like to have things as just going on, and I just remember as the new Hungarian civil code was accepted, it took 10 years just to educate lawyers, get used to something new, what we have. But disruption is not necessarily bad. It's something like forces us to revisit and even reconsider very fundamental concepts. I think it's surprising how fundamental concepts are that we don't really have the answer, like money. We never really thought in concept of money or the concept of security and securities and so on. And I think one of the starting point of the problems is that we have some kind of cognitive dissonance. And at the heart of this is the relationship of the law to reality. That's a very complex one. I wouldn't go into the details of that because I think law and reality should be just 2 days conference at the very outset, so I wouldn't do that, but we actually have a problem with it because our mindset is just to design, I think it's according to the human evolution, just designed to the physical world. We are prepared for risks of the physical world. We can grasp what we can visualize, but if there is something we can't visualize, like data, for instance, then we have a problem with it. Law is a very apt tool for address this kind of phenomena because, as I mentioned, law is just a product of the society. It's very abstract. Law doesn't have a problem. We have a problem. I mean, people have a problem because we can't imagine what is virtual. So we need something, at least a picture, how to imagine something. That's why I think we have a problem. We understand if we have a bill of exchange, which is a document. We have a problem if there is an NFT. What is NFT? It's a picture. Okay, I see that, but what is it actually? That's difficult. That's the very same with data, it's just an abstractions. And the problem is that we have written laws. Actually, it is a problem. I think it comes out also from the presentation of Tamás Parti today in the morning that if we have written laws, okay, give some kind of security, but on the other hand, it just limits our thinking, because if something is not in the law, we are just disturbed by that. So if there is a reality which doesn't really comply with legal theories, for instance, then we lawyers, because we are lawyers, we try just to decide if that phenomena should be left outside of the law or it shouldn't exist that way because we can't fit it in the law. But I think reality, at least from an economic point of view, is just the reverse. If there is something existing, and we don't have a very good ground not to have it, because we would say it's dangerous for fundamental values, because that's another thing. But if it's not dangerous, then we should simply just reconsider the legal framework, not just to deny reality. That's with digital assets, like saying, okay, I can't grasp it. That's not a thing, but a thing can be a property. What to do with that? Now, we have to reconsider the concept of property, because we can't say that if it's not a physical object, it doesn't exist in law. So that's why I think we have to be very open-minded. I just put a very short list of what should be reconsidered in law. Some of them are concepts that are very natural for us, like consent. Consent is just a paradigm of law, because it's about private autonomy. With me, things should happen that I give my consent to, and I say this consent should be informed. That's like in medical health care, just like in medical malpractice cases, the paradigm of health law is just informed consent. And it's a paradigm of everything what happens to us while protecting our privacy. For instance, we say it's an interfere to our privacy if I didn't give my consent. But if I give my consent, that's okay. But it is shown that we never really thought of this issue as lawyers. I mean, it's a fundamental issue in the society. What is consent? Where are the limits of the consent? Whether consent could be withdrawn? And what happens if it occurs? Where are the limits? How the other party should know that? But also another issue is decision or resolution. It comes from the Shufa case in a credit scoring example. If some kind of artificial intelligence is used, who decides? The AI, which is just determines the outcome and so on. But we also have to reconsider property. We have already seen it today. Transferability of assets. Also, role of written form was mentioned today. Money and securities. It's astonishing, but we don't really have a legal concept of money, and we want to do something with Bitcoin. That's a problem, because now we start to think of that. But I think it's a very good thing for us lawyers that we start to do that. Also, there are very fierce debates on liability issues. I don't want to touch upon those issues because our track is different. Also, personality, and I think just a couple of weeks or maybe months, just weeks ago, there was a conference in this faculty about techno-feudalism, which is something new. We try to get used to what happens in the economy and society. And also sovereignty is an issue, because maybe it can be a little bit surprising, but big tech companies, the platforms, they have a sovereignty. That's a very challenging statement, and I think that, again, a complete new conference should be organized for that. So if we get some rest from this conference, perhaps that could be our next project. But the very first thing I would like to mention in this four I mentioned was we have to rewire our mindset, because as civil lawyers, I remember very well, about 20 years ago, there was a lecture held in this faculty about human rights in private law relationships. And the reaction of civil lawyers was very, very negative. They said, okay, we shouldn't have this in private law. Just a couple of decades before that, there was the issue whether constitutional rights should be applied in private law relationship. But we said that no, that's not clear, that's very vague, very difficult. That's why we don't want to have them. Human rights is something which is an obligation of states created for themselves, but not for private actors. Today, everyone is just speaking of fundamental rights. It's like a common language for us, because we can't really assess those issues that are on the table today. Just we start to think of fundamental rights, even if we don't really like that. I remember we were also very negative about discrimination, because we visualize something like, okay, the anti-discrimination directives have been adopted and implemented, and that's the end of contract law, because there is no freedom of contract anymore. It didn't happen. But actually, we have to go on this way of thinking, and we have to learn on fundamental rights. All of the use cases we have in this area are about this type of rights. Also, there is a risk that decision-making is not transparent, but we want to have a transparent decision-making because we want to know what happens to us, why it happens to us. If our claim was rejected, our request was rejected, why it was rejected, we want to know that. That's why transparency is a very important thing, and technology doesn't really help in making those processes transparent. Also ideas that against the big tech companies, the so-called gatekeeper companies, online service provider companies, the enforcing of the rule of law should be used as a new framework. The second I would like to mention is consumer protection. Consumer protection just arrived in the 1990s. There was, I remember, I'm old enough to remember those debates over consumer protection as it just arrived in the EU. It has many problems, obviously necessary, but it's a problem to decide who is the consumer, who is not the consumer. This kind of distinction in the law, division in the law, like commercial law versus private law, consumer law versus civil law, it always just involves some kind of problems because there will be gray zones, there will be boundaries, there will be issues. But what I think that even consumer protection framework is something which should be left behind because we can't really use it. Consumer protection is about protecting economic interests of the weaker party of a contract. That's what consumer protection is about. But we don't speak of these issues anymore because not only a natural person is vulnerable if we are against the big tech companies, the online service provider, the gatekeeper companies, but also a bank can be a vulnerable person. Big companies are vulnerable. Everyone is vulnerable. There is no one in the society, natural or legal entity, who is not vulnerable. But also some cases like protection of children, who are the most vulnerable part of the members of the society. They are not contracting parties, but we should protect them. Also, we have cases with politicians in the social media. Is a politician a consumer or not? This was a question that was faced in Hungarian court practice. How we should assess these kind of cases. So I think this is something what we have today. It's very important to speak of consumer protection today, but I have a kind of vision that somehow we should left this framework behind. And also our remedies should go behind the consumer protection. Framework like disgorgement of profits should be considered against the companies because private law just reaches its boundaries. The main sanction of private law is damages. Damages is about the compensation, but damage should be proven, evidence must be provided, and if the damage is not proven or if the damage is relatively small, then it doesn't have any kind of preventive effect on big companies, not only in this high-tech technology sphere, but I think that nowhere, and we learned those from the Ford Pinto cases and other cases against the big car manufacturers, what we had so far. One thing about the blockchain, because I mentioned today in my introductory speech that it is our task to decide what is new and what is just an old phenomenon in new clothes. Blockchain has a very good features. It has many advantages. It makes possible real-time communication, proof of title, just transmitting transaction. We will have today speech about smart contracts, for instance. These are obvious advantages, but we have to see that this is not necessarily new. I mean, the result is not necessarily new, because if you say that one of the main advantages of blockchain just registering transactions in the order as they have been made, we have it in private law, because we have land registry. Now in Hungary we have, I don't know if we have, but we don't have. It doesn't work, I mean, this electronic land registry. It has been introduced, but we have so many problems that a couple of weeks ago, the Hungarian Bar Association just wrote a message to the lawyers that, well, be patient because it doesn't work, but it will work. So we put it into in an electronic way. And also securities were about that. I mean, a bill of exchange, which was just a transferable document, was done with just signatures on the document in the specific order as the transactions were made. But I think blockchain is very, very important to understand us, for us to understand how it works. But we have to go further with that, because now today we have something that blockchain is about digital assets. But we have to understand blockchain is a technology, is not necessarily only about digital assets, but may be used for many further and very useful way. And I would like to speak finally about the applicable law to digital assets, because I just realized that as Bitcoin and NFTs and many, many other coins and things, just tokenization came, we started to focus on the issue, what they are in the eyes of the law. Are they, could an NFT be a security, for instance? Because it works like that. It can work like that. Just give you a very simple example. If I make a token in the OpenSea or somewhere else, and on this token is that I, undersigned, but don't need it, I, Attila Menyhárd, just promised to pay 1 million Hungarian forint to anyone showing me this token in a year. And I also declare it should be qualified as a security, because that's on the basis of my private autonomy. Is it or not? Because then we go to the heart of the problem, is it a written or not a written form? I remember very well just a discussion more than 10 years ago with colleagues, lawyers for banks. We have 2 hours discussion. 2 hours discussion was about a very different forms of digital signatures, digital communication, and we try to answer whether they are in a written or they should qualify as a written or a non-written form, an email, an SMS, but also many, many other forms of digital communication. I remember very well there was a very important project in Hungary. It was under the auspices of the Hungarian National Bank, and the idea was just to make a DLT system where banks and insurance companies can communicate directly, because it's a very good thing to do that. Because if someone gets a loan, then it is required to have an insurance. And then the client shouldn't go to very different places, this insurance company, then back to the bank, and from the bank to the insurance company again. And if everything was changed later on, it also should be communicated. They said it would be a very good idea to make a blockchain. It was not a decentralized system, but even a blockchain, and in a DLT system to do that. Everyone agreed it would be very, very useful. Many works have been done, but the problem was that for certain kind of communication, the Hungarian civil code requires written form. And the problem was, we didn't know if I just click, is it a written form or not in a system like this? Does it qualify to the written form of the civil code? Later on, some kind of specific legislation solved that. But today, if we want to have a picture of the digitalization and written form in Hungarian law, someone who would speak about that would speak at least for 2 hours about that, just to give a very, very, very time-consuming list of the different specific legislation on that, which is for specific sectors to do that. So we started to consider these issues, money, NFT, and so on, but we never considered the issues, what the applicable law for this is. And the problem is that then we need a qualification, and qualification is just a two-way process, because in order to qualify something, whether it is money, whether it is a written form or anything else, I can do that only in context of the applicable law. I can assess this issue from one specific legal system. Is it written according to Hungarian law, for instance? But the problem is that in order to decide which is the law to rely on, should depend on the qualification again. So it's just a very, very difficult process. And the problem is that, and that's just a reference back to what I started with, reality and virtual world, that our rules on the applicable law are designed for real world. They are about geographical places, where the asset lies, where the asset was just registered, where the act of causing a loss was occurred. Always the question is where. There is no rule for if something is not where. That's why we should start with, if you ask money, then if you ask Bitcoin is money, then I should ask, okay, according to which law? But first we should decide if it is a money or not, because then we should go for that. And just I would like to give you a very brief overview on that there is no specific legislation on this issue so far. That's a very, very pragmatic problem. But everyone considering is like UNIDROIT, American Law Institute, European Law Institute, they give different answers. Someone says that private autonomy should get a priority, so the person creating the asset should define the applicable law. Others say, no, it doesn't really work, because it shouldn't be about private autonomy, but it should be about the public law of the state to decide how to do that. And now we have also a new project for a Hague conference, because they say neither the solution provided by the UNIDROIT, neither the solution provided by the European Law Institute or the American Law Institute are a satisfactory one for them. So thank you very much for your attention. There are no room for questions because we have a very tight schedule today, but I would be very glad to discuss those issues today in the coffee break, lunch break, in the evening, perhaps not in the evening, but in another occasion. So thank you very much for your attention. Thank you.